So California is now arguing that the Supreme Court's decision in Bruin has no impact on their handgun and rifle purchase restrictions. So let's talk about this. But real quick before we jump into this video, if you agree that California needs to stop violating our rights to keep and bear arms, go ahead and hit that like button and subscribe. So like I said in the intro, the state of California just argued to a federal district court that the Supreme Court's New York State Rifle and Pistol Association v. Bruin decision has no impact on California's handgun and rifle purchase restrictions. And they claim that is because the state's restrictions, which is only a restriction on purchases, and therefore it does not implicate the Second Amendment. The case we're going to be talking about in this video is Nguyen v. Bonta. This is a case which challenges the new California law, which prevents California residents from being able to purchase more than one handgun or semi-automatic centerfire rifle within any 30-day period. Now, prior in California, under California Penal Code Section 27535, subsection A, it stated that no person shall make an application to purchase more than one handgun within any 30-day period. So California had already established a law that an average law-abiding resident could only go into an FFL and purchase one handgun in any 30-day period. But as we all know, California is never satisfied with their restrictions. Therefore, a new law was passed which expanded that language, and it went from expanding it to only applying to handguns to also applying to handguns and semi-automatic centerfire rifles, including AR-15s, AKs, and those style of rifles. Starting last July, on July 1st of 2021, California's law now states that a person shall not make an application to purchase more than one handgun or semi-automatic centerfire rifle within any 30-day period. So that is the expanded language that applies to handguns and semi-automatic centerfire rifles in any 30-day period. Now, you may be asking yourself, how is the state of California enforcing this? Well, they're enforcing it through the FFLs themselves. They have penalties for an FFL that sells more than one handgun or more than one semi-automatic centerfire rifle within any 30-day period. And also, they make it a misdemeanor for anyone to actually purchase more than one handgun or rifle or a combination of those two within that 30-day period. So they're applying it and enforcing it at the FFL level, at the store level, and then they're also enforcing it as a misdemeanor against any individual who makes this type of purchase. Now, of course, all of this did not sit well with California residents and 2A advocates, so a lawsuit was filed in the Southern District of California against the state of California in this new law. In the lawsuit, it's argued that the state of California had no rationale for barring the purchase of more than one handgun when they originally passed that first law, and they also had no additional rationale or evidence of why they needed to expand that language to also apply to those semi-automatic centerfire rifles. This law's entire goal is to have a chilling effect on the legal purchase and ownership of firearms within the state of California. That is the ultimate goal of this, is to actually stop purchases. Now, in this case, Nguyen, both the state of California and the plaintiffs filed for cross motions for summary judgment, and essentially they're seeking to end this issue and case right here and now. In simplest terms, a motion for summary judgment and cross motions are simply requests by either party, and essentially here is both parties, asking the court to decide all or part of this lawsuit right here and now without going to a full trial. In the plaintiff's motion, they argued that this law was invalid under the old balancing of interest standard that the Ninth Circuit has used in the past, but they also argued that this law in the state of California is invalid under the correct standard of review, which is text as informed by relevant history and tradition. This argument for text as informed by history and tradition was made even before the Supreme Court ruled in the New York State Rifle and Pistol Association v. Bruin decision. And as many of us know, the Supreme Court did issue a ruling in Bruin, and they rejected the Ninth Circuit's use of the two-step approach, and they rejected the balancing of interest, and instead they reaffirmed that text as informed by history and tradition is the entire test when you look at the Second Amendment cases. In fact, Justice Thomas, in writing for the majority opinion, stated, "Today we decline to adopt the two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command." And because of that language, the district court judge here in the Nguyen case requested supplemental briefings and requested that both sides outline what standard review now applies and how the Bruin decision impacts this case and their requests for motions for summary judgments. In response to that request by the district court, the state of California just filed their supplemental brief, and essentially they argued that this case is not impacted or altered whatsoever by Bruin, and in fact they argue that the Bruin case has no bearing on this issue at all, mainly because they argue that purchase restrictions do not impact or implicate the Second Amendment and the right to keep and bear arms. In fact, California states, in this case, California's 1 in 30 law only limits individuals to purchase of one handgun or semi-automatic centerfire rifle every 30 days from licensed firearms dealers. It does not prevent anyone from acquiring firearms for self-defense, keeping them for those purposes, and bearing the firearms for confrontation. Thus, the proposed course of conduct, purchasing more than one handgun or one semi-automatic centerfire rifle from a licensed firearms dealer within a 30-day period, does not interfere with an individual's ability to keep or bear arms and is not covered by the plain text of the Second Amendment. So there, California argues that the right to keep and bear arms does not mean you as an American are able to purchase any firearm you want whenever you want. In their eyes, as long as you have access to get at least one firearm for your self-defense, that is the whole point of the right to keep and bear arms, and they argue that a purchase restriction which limits when and what you can purchase does not implicate the Second Amendment. In fact, the state of California goes even so far as to say that California's 1 in 30 law does not prevent law-abiding citizens from keeping and bearing arms of any sort. Accordingly, they argue, under Bruin, the burden does not shift to the government to support the regulation with the historical analysis, and instead they say that the plaintiffs have failed to show that the Second Amendment is implicated in this case. So in the state of California's brief, they deny that the 1 in 30 law and the purchase restriction impacts the right to keep and bear arms, and therefore they claim that they don't have to support their restriction with any history or tradition dating back to 1791 like the Supreme Court ordered in Bruin. Here they're saying, whoa, this does not implicate the Second Amendment. It does not implicate the text of the Second Amendment. Therefore, we do not have to justify our restriction. So this is one of the new strategies that the states like California are shifting to. Instead of trying to lean on interest balancing or public interest like they've done in the past, now they're just saying, well, none of this stuff implicates the Second Amendment. However, the state of California then concludes their argument by stating that if the court here disagrees and finds that the restriction, the 1 in 30 law, does in fact implicate the Second Amendment and the text and the right to keep and bear arms, then the court here should give them more time, even more time, to present additional expert discovery and history to support and justify their restriction. In fact, California recycles the same arguments that they made in the Miller v. Bonta case, the ban on so-called assault weapons case, which was presented to Judge Benitez. In fact, the language that they use in this case, Nguyen, to justify why they should need more time, those same arguments were denied and rejected by Judge Benitez. The state of California and Miller wanted to push that case out for an additional 6 months, but Judge Benitez said, no, we're not going to do that. We're not going to drag this out any longer. You do not need all this time to come up with some history or tradition. You get 30 days, he did in that case. So hopefully the judge here does the same thing, rejects this absurd argument that first, that the Second Amendment is not implicated, but then even if it is, that the state of California should be given so much more time to drag this case out even longer. So this is an interesting case because now you have California unveiling some of their new strategies in regards to the Second Amendment cases. They now plan to simply argue that all of their restrictions do not implicate the text of the Second Amendment, i.e. the right to keep and bear arms. Because of this, they argue they don't have to follow the Bruin decision, what the Supreme Court outlined in Bruin, and they don't have to justify their restrictions with text and history and tradition. But we will definitely be keeping our eyes on this case. If you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.